Ladies and gentlemen, I do start by apologising if I kept you a little delayed and you could all be over looking at the great displays from the exhibitors, but I do apologise. There was a bit of a media scrum out the front, and as much as I'd like to say that all media are always interested in sort of the issues of body corporate and all the things you're here for, it was more about halal eating prisoners today if you read the front page of the Courier Mail. But in dealing with that, I've also dealt with what we're all here about today, and that's of course in this Body Corporate Trade Show. Prior to leaving today, I'll get a chance to go around to look at the exhibits, but I think it's great that SSKB have put this particular exhibition on for those of you who may be managers, caretakers, unit owners, or body corporate managers. Let's do a straw poll here. We know who the body corporate managers are, SSKB. Any other body corporate managers in the room? Caretakers, letting agents. We know that body corporate in Queensland is such a big part of our economy. I used to practice before I was Attorney General and member for Quina in 2009. I used to practice in body corporate law on the Sunshine Coast. So I've seen it all. I've acted for managers, I've acted for unit owners, I've acted for body corporates, I've acted for unit owners fighting with other unit owners. I've acted for body corporates fighting with the chairman of body corporates. I've acted for chairman fighting with other residents. So I've seen it all. I've seen the ups and downs of community title living. But I'm pleased to say there's certainly more ups than downs. And I think in any situation you've got personality clashes. And of course we're not here to deal with that today. But to give you a bit of a synopsis of where I see body corporate and unit development going in Queensland, we have 4 pillars of our Queensland economy that the government always brags about. And they're 4 things including, which will be of interest to you: tourism, construction, and the other 2 industries that we're fighting for in Queensland is agriculture and resources. For far too long, governments have just put all the money and investment into one basket, and that's been resources. And we see what happens when you invest just in one particular industry, like the mining industry, and it's on its way down. You need other industries to back it up. That's why we're investing in these 4 pillars, where we're saying that it may not be all the time that one particular pillar is sort of, or they're all down. It may be that one particular pillar is up, but what we're trying to do is get them all up. So tourism and construction, particularly of interest to those in the body corporate industry, and particularly to our exhibitors here today. A bit about my background as a lawyer in body corporate law. As I said, I've acted for all forms of body corporate. I really enjoyed body corporate law, and I was started to get my teeth into it when I was elected in 2009. Little did I know that in the short space of 3 or 4 years I'd be the Attorney General and responsible for the Body Corporate Community Management Act, responsible for the Property Agents and Motor Dealers Act, the Property Law Act, the Land Sales Act, Workplace Health and Safety Act, Industrial Relations Act, Gaming Machine Act. In fact, 223 pieces of legislation I'm responsible for in Queensland, and of course Criminal Code and dealing with all our laws and tribunal and judicial officers. So it's a very wide portfolio, but I think there's great potential for the body corporate law. If I can give you an example of a couple of things that we've done, and I know I'll deal with lot entitlements too, because I know that that was particularly of interest at the Gold Coast and other areas around Queensland. But I want to give you some examples or my rationale why we did what we did a few months ago in the fixing the 2011 amendments that went through. Since coming to government, we've done a few things. You will all have heard that we're very much interested in reducing regulation, red tape, the burden on people, whether that's buying or selling a property in Queensland, whether that's a caretaker, a letting agent doing what they do best, and that's running their businesses, or unit owners buying and selling units in Queensland, buyers and sellers of all forms of property. We immediately got rid of the sustainability declaration. Now, those who've experienced buying units in Queensland, also the seller had to prepare what we called a sustainability declaration. It was a new innovation to help climate, or to help the effects of climate change. What it really was just a piece of paper to show governments were doing something in that regard. Anyway, we abolished it. And we abolished it because it added 2 pages of regulation. That the funny side of it was that the law said you had to fill out the sustainability declaration. You had to provide it to the seller, to the buyer of the property, but you didn't actually have to fill it out if you didn't know what the answers were. So most agents and lawyers were telling us, and real estate agents were telling us, that it was just always not applicable because no one wanted to fill it out. I always give the example, I sold my property to my brother, and I had to fill out one of these bloody sustainability declarations, and I just put not applicable, because it asks questions. You know, if you had a dual flush or a single flush toilet, how many litres does it flush? Who keeps a box when they install a toilet? When a builder installs a toilet, or you upgrade or renovate, who keeps a box to say how many flushes? In fact, if you were listening to the ABC this morning, you would have learned something that I did, that litres of toilet flushes have gone from 12 litres down to 4.5 litres and a little less for a single flush. Now, who's to know that? Who wants to know that? You just want to flush a toilet, make sure water comes out and goes down. It also said things about your lights. If you have fluoros or the energy-saving devices. Again, when a buyer comes into a property, they want to know the house looks good. And I said to my brother, when I told him the house is full of downlights, I said, if you want to put fluoros in, go ahead. Just pay me the money that I paid for the downlights. They look a lot better than fluoros, but if your choice when you buy the house, you want to change it, go ahead. So anyway, we've just abolished the student sustainability declaration. The other things we're looking at, I've just completed a full review of the Property Agents and Motor Dealers Act. Now, who has bought and sold property in Queensland or had some interest in buying and selling houses or units in Queensland? You would have seen over the years, now although the Property Agents and Motor Dealers Act may not have a direct relevance to body corporate law, in terms of selling units, it does. Because all the regulation and red tape about your contracts that you sign and enter into is very much involved about what the Property Agents and Motor Dealers Act says. So we're going to do a few things. One, we are splitting the Act, so there's industry-specific legislation. So the motor dealers will have their own piece of legislation. Not only are we doing that, we are getting rid of a lot of the government forms. So if you have in the past filled out one of these forms, which is and these are announcements I'm making today, the Warning Statement 30C, which is a 2-page document where you buy a property and it warns you about the contract. Despite you having the ability to read the contract, and before you sign, you get all the sort of independent legal advice. Government at the time thought it would be good just to give you a warning about the warnings contained in the contract. Now, I've had a personal pet hate on this because when I was in practice, these came in, and you had a lot of issues on the Gold Coast where most of the terminated contracts were in fact because of this form. So the bright sparks that came up with these ideas said not only do you have to have this form, you have to attach it to the contract. And then the Supreme Court had to work out what attached means when an agent gives you the contract. Does a bulldog clip mean attached? Is it stapled? Does it have to be physically attached? Is a ring binder attached? Because there were some contracts where it was attached but at the back, and that was found to be invalid, and a lot of contracts got terminated. So then they changed it. They said, well, it has to be attached as the first and top sheet of the contract. So it was just like digging this hole. Government was just digging this hole and we were getting more contracts terminated. So I became Attorney General. The best thing we can do, ladies and gentlemen, is abolish the form. So that's going to be gone. The second thing I'm going to abolish is if you buy a unit in Queensland, not only did you have to fill out that 30C warning statement, you also have to fill out the BCCM Form 14, which is the information sheet. Ladies and gentlemen, that is going to be abolished with legislation I'm introducing this year. So immediately, when you buy a unit in Queensland, you've saved 4 pieces of legislation. Add the 2-page sustainability declaration to that. That is 6 pages by the end of this year that a consumer will not have to fill in. A seller of a unit will not have to fill in, saving 6 pages of regulation and red tape. Now, I'm hoping that gives an indication of where, when we talk about reducing red tape and regulation and burden, we're serious about it. And if the forms can't, and if no one can convince me that the forms ought to be there, then the best thing is we'll abolish them. Now, this is the sort of stuff that was put in because of all under the guise of consumer protection. But ladies and gentlemen, the consumer has been less protected. Because if anyone thinks the consumer reads all that, and I was a lawyer, I know they don't. Hands up if you've signed a document and you haven't read the small print, you haven't read the big print. Hands up if you've ever done that before. Haven't we all, gentlemen? With those forms, don't help the consumer with respect to that. What helps the consumer is making sure the consumer is better informed through their agents, their lawyers, education, the property agent sector, the body corporate sector, body corporate managers, in terms of the best advice they can give. So that's 6 forms that we're deleting by the end of the year. So we're about to introduce legislation which I've had approved through Cabinet, which will streamline many of the processes with respect to property law in Queensland. Now, body corporate. You have the Body Corporate Community Management Act. You also have the Property Agents and Motor Dealers Act, the Property Law Act, the Land Sales Act, and the Land Title Act, all encompassing a little bit of what everyone does, or whoever has an interest in body corporate law. What we did a few months ago was introduce laws. You'll recall in 2011, prior to 2011, there was a law that said you could run off about your lot entitlements. You could go to the QCAT tribunal and you could get an adjustment order made. So we had a number of adjustment orders made by QCAT or the courts, and then they were what the lot entitlements were adjusted to. In 2011, there were amendments made by the former government that said one person in a body corporate can move a motion without dissent, without debate, and it is to be passed automatically. And it would revert the reversion made by the independent umpire, i.e. QCAT or the court. Now, we objected at the time, and I was in opposition. We objected to it at the time and said, fundamentally in a democracy, we don't believe you should have the right, as one member, going to a committee, going to a body corporate meeting and move a motion without debate, without dissent, and have it passed. So what I did was 2 things. One, I established that the reversion process, those that had done that and gone through that process, would have the option to go back to the court determination or the QCAT tribunal determination. We're only dealing with a very few across the state, and the advice that I have is not many, even despite the legislation that I've introduced, not many have actually in fact taken up that option. There's a few controversial ones, there's one on the Gold Coast particularly, and I'm not sure what the state that's in. But that was the first thing. But I also made a promise at the time of doing that. I said that we would also try and sort out once and for all the issue of lot entitlements in Queensland. Now, some have tried, failed spectacularly, because we know the emotion behind it, and there's an issue that people 1 week can be paying X for their lot entitlements, and the second week an adjustment's made and they're paying more or less. And you'll always have winners and losers when you adjust the lot entitlement. Someone's going to pay more, someone's going to pay less. And what rationale do you put for the entitlements? Is it an equal entitlement? Should everyone pay the same? Should people who live in bigger places pay more? Should people who have a more exclusive use of particular places pay more? So what I'm announcing to you today is that we have now, upon me saying we're going to do something, I'm announcing today that we are now going to do a full review of Body Corporate and Community Management Act, including lot entitlements, the rationale behind lot entitlements. The people that we're conducting this review is the QUT Property Law School. So rather than government doing it, I've got the experts who deal with property law, Professor Sharon Christensen and Professor Bill Duncan. We have engaged in a contract with the Research Law School to conduct over the next couple of years a few things. One of them is the BCCM Act, including lot entitlements. I've also thrown in the issue of governance of body corporate committees. I get lots of complaints each week about, does the committee have the power to do this? Does the committee have the power to do that? Can one individual in a committee unilaterally go and do this? So we're going to put that into the equation as well. As well as that, they're going to review the Property Law Act. And if we can consolidate our laws in Queensland, if we can come up with a rationalisation about how we look at lot entitlements, which most of you would be interested in, then that would be good. It would be good for you all, it would be good for industry. Whether we can get to a situation where everyone's going to be happy, I don't know. If you've got suggestions, we'll be more than happy. What we're going to do with this review, though, ladies and gentlemen, so it's not an in-house review from the department. That's why I've outsourced the review to the QUT Law School, which we'll be working with, and they'll set up a committee. the great thing about this review is that they're going to issue discussion papers and issues paper on all these separate issues. And then the community, you all, are going to have direct access to the research team to have your say. So rather than giving it to politicians to make determinations and wondering whether it gets to my desk or what the story is, they'll have public inquiries, they'll go around the state, they'll talk to people, you'll be able to put in submissions about lot entitlements. So my invitation to you all today is if you have the key to solving this mystery, if you have the key to make everybody happy in a body corporate scheme, please, now is your opportunity. I can tell you, I don't want to be having this debate in another 2 years' time. If you can look at all the issues associated with body corporate lot entitlements and the governance structure around committees and empowering the committees, liability for committees and things like that, this is an opportunity I think that will be great for Queensland, because we do want to, rather than individually assess pieces of legislation, what we're going to be doing is looking at all of it. And if we can get rid of a lot of the confusion around body corporate law, if we can take out parts of the PCCM Act that are in the property law, if we, it may be that we combine some of the legislation to really try and reduce regulation of red tape and burden. As I said earlier, I think the more regulation and red tape that we put on people and business and consumers, the more confused the consumers and business get. And the cost to business, I might add. With the costs that businesses have had and all these exhibitors around here in workplace health and safety and other laws that governments have introduced, on these businesses, with all probably good intent, just haven't worked because it's just costing hundreds and hundreds of thousands of dollars for business to work their way through workplace health and safety laws, industrial relations laws. So, ladies and gentlemen, a lot in the Gold Coast, a lot of people in the Gold Coast have been wondering for some time now, when is this review happening? What shape of the review? How it's formed? Well, there's the answer. It's the QUT research faculty in the law school, and if those of you who know Sharon Christensen and Bill Duncan, they are very experienced in property law, and they are very much open, and their direction from me to the QUT law school is very much about making sure that the community have a say. The people living in body corporates have a say. The advice that I have been given and the direction essentially that I've given is that sort of by the end of this year, the discussion papers, 2 discussion papers should be issued. One around seller disclosure, looking at a regime around seller disclosure about what people do when they buy into these complexes, and secondly, the lot entitlements. So we're going to try and hit the big issue, the controversy issue up front, and then hopefully we'll have an arrangement by which at the end of it we can implement that may try and get the balance right and try and deal with the issue once and for all in Queensland. They'll be looking at every jurisdiction around the world. They're not just going to be looking at Australian jurisdictions, they're going to be looking at all jurisdictions around the world. So ladies and gentlemen, can I, in conclusion, thank you all for coming to the trade show today. Can I thank the exhibitors around the room for the roles that you play with respect to community title schemes. And on talking about community title schemes, one final note, ladies and gentlemen, is the other thing that we've just legislated to help ease a bit of regulation red tape around selling properties in Queensland is the requirement that when a purchaser buys property, the agent or the seller has got to give a copy of the community management statement. Now, some of these properties at the Gold Coast, the community management statements are hundreds of pages long. My belief is, if a buyer is buying a property, they have the right to go to the body corporate manager and do a search and due diligence. And I think in a buyer beware market, that's where we should be at, not putting the responsibility on real estate agents to photocopy hundreds of pages. It should be the buyer's responsibility to fully investigate the matters subject to a body corporate, and that's why we have body corporate managers to work with. So, ladies and gentlemen, thank you all again for coming to the trade show today. It's been my pleasure to come and welcome you all today. I hope you get something out of it, and I think, Mr. Chairman, I'm here to answer questions if you're happy, but otherwise, ladies and gentlemen, there is a bright future for community titles in Queensland, and I thank you for all the respective roles that you play in this bright future.